Some years ago, a client, and he was not a client at that time, he inherited a foreign corporation. And it was a mid-sized foreign corporation. He wasn't the only owner there, but he was a partial owner, a minority owner there. In a foreign country, the classification of entity may not be exactly in line with the US tax classification. So to figure out whether this is a corporation or partnership, you have to really look into how this company operates, what the law says, how it operates. So he comes to a business lawyer. And actually, there was an accountant involved in this case as well. But in this case, we'll talk about the next step after that. But why the accountant might not have been the best choice there. But an accountant was involved there, but the chief role was played by the business lawyer. And the business lawyer was involved in some years before, prior to that, he was involved in another transaction. And in that transaction, he was advised by the accountant that the Form 5471 has to be filed, and about the penalties associated with the form. So he says to the client, you know what? We don't know what kind of entity this is, and I know about this Form 5471. And based on what the accountant told me, I don't think that your entity is actually a corporation. I think it's a partnership. You're a minority owner. That means that Form 8865 doesn't apply. You don't have the 5471 requirement. That's going to be an easy way to get rid of the IRS penalties associated with Form 5471. What he forgot about, well, two things. One little detail about income. If it's a partnership, it's a pass-through entity. That means that this client was in income tax non-compliance since the time that he inherited the company. And for this client, that would mean that he was underreporting about 90% of his income in each year. And the second issue is obviously the one that I already mentioned. You actually have to look at what the law says. The local law, how does the company operate before you cannot just randomly say, this is a foreign partnership and this is a foreign corporation, just because some of the details are here or some of the details are not here. In the end, we were able to go back to it was actually a corporation, it wasn't a partnership, so we were able to do a 5471 voluntary disclosure, and we were able to end that issue without any penalties. But if the IRS would have, what would happen if the IRS would have accepted this and audited his tax returns, discovered that he had underreported his income by 90%? Tremendous penalties would ensue.